Well, good afternoon and welcome to all of you. This is another of the San Fernando Valley unit of the League of Women Voters of Greater Los Angeles, another of our outstanding programs. We are pleased to have all of you welcome us to. We're pleased to welcome all of you today, and we are very honored to be joined once again by Erwin Chemerinsky. And we're going to we'll talk a little bit about the league at the end of our program, but I want us to get started with our speaker right away. So welcome, Dean Chemerinsky.
Thank you so much. It's always a pleasure to speak with you. Let me talk for a bit about why this is such a momentous time in the United States Supreme Court, and then be delighted to use a good deal of our time for any questions that you have. Let me make 3 points with regard to the court. First, how dramatic the changes in the law have been over just the last few years. I wrote a constitutional law casebook for law students and did the first edition 30 years ago. Over Labor Day weekend, I finished the 7th edition. I've never had an edition where so much of the law has changed as what we've seen over the last few years. In fact, I would even say that the 7th edition is more different than any edition that there's been since the book was first done 30 years ago. Let me tell you what I mean, but especially focus on the decisions from June of 2023. Obviously, what most comes to mind, a decision from June of 2022 in Dobbs versus Jackson Women's Health Organization. As you know, in 1973, in Roe versus Wade, the Supreme Court held that state laws that prohibit abortion are unconstitutional if they prohibit abortions prior to viability, the time at which the fetus can survive outside the womb. In 1992, in Planned Parenthood versus Casey, the Supreme Court reaffirmed that states cannot prohibit abortion. But in Dobbs versus Jackson Women's Health Organization, the Supreme Court expressly overruled Roe and Casey. The court said that the issue of abortion is left entirely to the political process. We've all seen the effects of this in terms of women's lives, in terms of where abortions are performed, in terms of our political system. But this is just one of many Supreme Court cases that's dramatically changed the law. Let me talk about cases that came down just on a couple of days on June 29th and June 30th of this year, and how much they have changed the law. Let me start with the affirmative action case that came down on Thursday, June 29th. It's Students for Fair Admission versus President and Regents of Harvard College. In 1978, in Regents of the University of California versus Bakke, Justice Lewis Powell wrote the pivotal opinion, and he said, college universities have a compelling interest in having a diverse student body. College universities may use race, said, as one factor among many in admission decisions to benefit minorities and enhance diversity. But he said there couldn't be quotas or set-asides on the basis of race. 25 years later, in 2003, in Grutter versus Bollinger, the Supreme Court reaffirmed this. That case involved the University of Michigan Law School. In its admissions decisions, it considered many factors. Race was one of them, with the goal of enhancing diversity, with the goal of benefiting minority students. The Supreme Court 5-4 upheld that as constitutional. Justice Sandra Day O'Connor wrote the opinion for the court. She stressed the compelling interest that college universities have in having a diverse student body and having diversity in their classrooms. As recently as 2016, in Fisher versus University of Texas, Austin, the Supreme Court reaffirmed this. That case involved the University of Texas undergraduate admissions. It, like Michigan Law School, and like Justice Powell had prescribed, used race as one factor among many in admission decisions to benefit minorities. The Supreme Court upheld the University of Texas affirmative action program. Well, if the court just upheld affirmative action 7 years ago, why was the matter before the Supreme Court now? Had the court found some musty history of the 14th Amendment that led it to believe it made a mistake? No, all that had changed was the composition of the court. There were 3 dissenters in Fisher, Chief Justice Roberts, Justice Thomas, and Alito. Since 2016, there are the 3 justices appointed by President Trump: Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett. These 3 justices joined with the 3 dissenters from Fisher to create a new majority, 6-3, to hold that college universities cannot engage in affirmative action. There were actually 2 cases before the Supreme Court. One was Students for Fair Admission versus University of North Carolina. The other was Students for Admission versus Harvard College. Why 2 cases? Well, the Constitution, and therefore equal protection, apply only to the government. Private entities don't have to comply with the Constitution. The University of North Carolina case involves whether its affirmative action program violated the 14th Amendment's Equal Protection Clause. But Title VI of the 1964 Civil Rights Act says recipients of federal funds can't discriminate on the basis of race. The Supreme Court has said that the same standards apply under Title VI as under the Constitution. So the significance of 2 cases is that the Supreme Court's decision applies to all public and private college universities in the United States. Chief Justice Roberts wrote the majority opinion. He said that college universities do not have a compelling interest in having diversity in the body. He said that inevitably affirmative action programs are harmful. They discriminate against those who are not admitted. They stigmatize on the basis of race. So therefore, programs like the North Carolina, like the Harvard program, are impermissible as violating equal protection in Title VI. Justice Thomas wrote a concurring opinion where he said he reads the history of the 14th Amendment as requiring that the government always be colorblind in its decisions. Justice Gorsuch wrote an opinion which he said, we don't even need to consider equal protection. All colleges get funds from the federal government. Title VI applies to them all, and affirmative action violates Title VI. Justice Kavanaugh wrote a concurring opinion which he said, there always had to be a time when affirmative action would end. We've reached that time. Justices Sotomayor and Jackson wrote vehement dissents. They were joined by Justice Kagan. Justice Sotomayor looked at the long history of racism in the United States and talked about how, in light of it, having the government ignore race is to perpetuate discrimination. She said that eliminating affirmative action will have, this was her word, I quote, a devastating effect on diversity in many colleges and universities. She pointed to the experience in California. As you know, in 1996, California voters passed an initiative, Proposition 209, to abolish affirmative action here. Under Prop 209, California, and all aspects of government in California, cannot discriminate or give preference based on race or sex in education, contracting, and employment. Justice Sotomayor, in her dissent, pointed out that after Prop 209, the number of Black and Latinx freshmen at Berkeley and UCLA fell by over 50%. For UCLA, it took 19 years till 2015 to get back to its pre-1996 levels of diversity. Justice Sotomayor pointed out for Berkeley, as recently as 2019, it hadn't gotten back to its pre-1996 levels of undergraduate diversity. Justice Jackson wrote a strong dissenting opinion. She began by contrasting 2 hypothetical students, both in the state of North Carolina. One was the 7th generation in his family to go to the University of North Carolina. The other was the 1st generation in his family to go to college. The latter was descended from enslaved persons. She talked about the differences in the lives of these 2 individuals and what the legacy of slavery and discrimination has meant with regard to the state of North Carolina in the latter student. She pointedly disagreed with Justice Thomas. She said that there's nothing in the Constitution or the history of the 14th Amendment that requires colorblindness, and that colorblindness is simply to ignore the history that requires remediation now. It's interesting, Justice Thomas is the second Black justice. Justice Jackson is the third Black justice to serve on the court, and they could not draw more different lessons from their experience. Well, I think there's going to be crucial questions to be litigated after the Supreme Court's decision. One is, what can college universities do to achieve diversity? College universities can certainly continue to pursue diversity, but what they can do is limited. But there's many unanswered questions. Can there be targeted outreach and recruitment of students of color? The admissions process has three basic phases: getting students to apply, making decisions about who to admit, and recruiting students. The Supreme Court's decision involves only the middle phase. What are the implications for the first and the third? What about race-neutral laws that have the purpose and the effect of diversity, so-called race-neutral proxies? Take the University of Texas. It adopted a top 10% plan, it's now top 6%, where they would take the top 10% of all of the public high schools in the state. Texas is sufficiently racially segregated that this would lead to some degree of diversity. Is it permissible because nowhere it mentions race? Or is it impermissible because it's done with the purpose and effect of diversity? At the end of his majority opinion, Chief Justice Roberts said, there's nothing in this decision that precludes colleges and universities from considering race and looking at how a student overcame discrimination, or how race was an inspiration for the student, or the role of race in the student's life. But think of it from the perspective of an admissions committee. It can't give a preference based on race, but it can look at how a student overcame racial discrimination, or race was an inspiration, or the role of race in the student's life. How is that distinction to be drawn? A second major question is whether the Supreme Court's decision is going to be extended to other areas of law. Take, for example, employment. The week after the Supreme Court's decision, the beginning of July, 17 attorney generals, all from what we'd call red states, sent letters to Fortune 500 companies saying that no longer can they engage in affirmative action with regard to employment decisions. A senator from Oklahoma, Senator Cotton, sent letters to companies and to law firms saying that no longer can there be affirmative action in employment. The Supreme Court's decision was just about college universities, but will it be extended to employment? Two law firms, Morrison and Forster and Perkins Coie, have now been sued for their diversity programs. How much will the Supreme Court extend its ruling of education, say, to the employment area? The Supreme Court last dealt with employment in the context of affirmative action in cases in 1979 and 1986. The Supreme Court is so different now than it was then. But the point I'm trying to make is the law that had been followed for 45 years was overruled by the Supreme Court, just as Dobbs overruled Roe, that had been the law for 49 years. Another case that I want to talk about is 303 Creative versus Alenis. It came down the next day, Friday, June 30th. Colorado has a law that prohibits business establishments from discriminating based on race, sex, religion, sexual orientation. Lori Smith has a business of designing websites. She wants to expand her business to design websites for weddings, but she doesn't want to design websites for same-sex weddings. She said that would violate her religious beliefs. She brought a lawsuit in federal court in Denver, and she wanted the court to declare that to apply the Colorado law to her, when she refuses to serve same-sex couples, would violate her free exercise of religion and her freedom of speech. The federal trial court in Denver and the Federal Court of Appeals ruled against Lori Smith. They said that Colorado has a compelling interest in stopping discrimination based on sexual orientation. The Supreme Court, in a 6-3 decision, reversed and ruled in favor of Laurie Smith. Justice Gorsuch wrote for the court. Justice Sotomayor wrote for the dissenters. The court focused only on Laurie Smith's claim of free speech. It didn't discuss her religion claim. And Justice Gorsuch said, the First Amendment prevents the government from compelling people to engage in expression. The court said, Laurie Smith is engaged in expressive activities when she designs websites. She writes the content for them. The court said, for the government to force Laurie Smith to do websites for same-sex weddings would be impermissible compelled speech. This then violates her rights. Justice Sotomayor, in her dissent, explained why this is such a major change in the law. Never before in American history had the Supreme Court held that business establishments have the right to discriminate in a way that violates the law. There have been, as Justice Sotomayor pointed out, many efforts for people who want to discriminate to say, we're engaged in expressive activity, that we should have the right based on freedom of speech or freedom of religion to discriminate. But never before had the Supreme Court upheld that. Justice Sotomayor pointed out the implications of this. This applies to anyone who's engaged in expressive activity. Expressive activity is not defined by the court, but it seems very broad. In the wedding context, there have been claims by those who design and bake cakes, who make floral arrangements, who take videos, who engrave stationery. They're engaged in expressive activity. A couple of weeks after the decision came down, a hairdresser in Michigan brought a challenge and said, my hair cutting is my expressive activity. And people who make cabinets, people who almost any work can say that it's an extension of themselves and they're expressing themselves through their work. All of these individuals that engage in expressive activity can refuse to provide service. And it's not just refuse to provide service to gay and lesbians. What if Laurie Smith said, interracial marriage violates my beliefs. I'm therefore not going to provide service to an interracial couple. And it's not limited to religious beliefs. It's any beliefs would be a basis for refusing to provide service. The court here has opened the door to discrimination in a way we haven't seen previously. I can put it another way for you. There's always a tension between liberty and equality. Any law that prohibits discrimination limits the freedom to discriminate. But the Supreme Court for decades has said, stopping discrimination is more important than protecting the freedom to discriminate. This case is so important because the first time the Supreme Court has said freedom to discriminate is more important than stopping discrimination. One more case that's a change in the law. This case called Biden versus Nebraska. It also came down on Friday, June 30th. There's a federal statute. It's referred to with the acronym, the HEROES Act. It says that the Secretary of Education can waive or modify student loan obligations in an emergency. It's this authority that President Trump used to suspend student loan repayment obligations early in the pandemic. President Biden continued it on taking office. President Biden then made it permanent. He gave 43 million Americans up to $20,000 of student loan relief each. Nebraska and 5 other conservative states brought a challenge to this. And on June 30th, the Supreme Court ruled against the Biden administration and said they could not do this. Like 303 Creative, like the affirmative action case, this was 6-3, with the 6 conservative justices in the majority and the 3 liberal justices dissenting. Here, Chief Justice Roberts wrote for the court, and Justice Kagan wrote the dissent. Chief Justice Roberts said, when it's a major question of economic or political significance, an administrative agency can act only if there's clear direction from Congress. Chief Justice Roberts said, this case involves a major question of economic or political significance. The total cost of the student loan relief would be about $450 billion over many years. He said Congress wasn't sufficiently specific in authorizing this, therefore it's impermissible. Justice Kagan wrote a strong dissent joined by Justice Sotomayor and Jackson. Justice Kagan said, the most basic principle of statutory interpretation is when the language of the law is clear, it must be followed. She said here, the language of the law is explicit. The Secretary of Education can waive or modify student loan obligations in emergency. No one contested the emergency. And she said, hard to imagine what Congress could do that would be clearer in authorizing waiver than to say the Secretary of Education can waive student loan obligations. Well, this case is significant for the 43 million people who won't get student loan relief. The case is also significant. The Supreme Court, for the second year in a row, has said, if it's a major question of economic or political significance, an agency can act only with clear direction from Congress. Ask yourself, what's a major question of economic or political significance? What's sufficiently specific congressional guidance to meet this? The Supreme Court doesn't say, it's never said. And this opens the door to challenges to almost every kind of federal agency regulation, environmental regulations, health and safety regulations, regulations of business. So these are just a few cases, but I think you can see why I say there's been such dramatic changes in the law. I can give you many more examples from just the last 2 years. Well, let me go to the second part of my remarks, the ethics issues surrounding the Supreme Court. Every judge in the country, state or federal, is bound to obey an ethics code, except for the most important judges in the country, the Justice of the United States Supreme Court. The only justices who are not covered by a code of ethics are Supreme Court justices. I regularly speak to judges. I spoke at a federal judges conference last Thursday. I spoke at a state judges conference this past Sunday. And I find the audience that's most outraged by the lack of an ethics code for Supreme Court justices are the other judges. Why don't the Supreme Court justices have to follow the same ethical rules that they all have to follow? There have been serious allegations of improprieties involving several of the Supreme Court justices. The Supreme Court, I think in part because of this, now has its lowest approval ratings in all of American history. A Quinnipiac University poll from June showed that only 30% approve of the Supreme Court's performance and 59% disapprove. A Gallup poll showed only 25% of the public expressed confidence in the Supreme Court. As I say, I think some of that is because of the ethical issues. I regard this as a self-inflicted wound by the Supreme Court. There's no reason it can't promulgate an ethics code for itself. Apparently, from what I've been able to tell, Chief Justice Roberts would like to be unanimous among the justices, but there isn't unanimity among the justices. The judges would tell you that many people can't distinguish Supreme Court from lower courts, state courts, and federal courts. The tarnishing of the Supreme Court's image because of this then tarnishes all of the legitimacy of the courts. My hope would be that the justices on their own would promulgate an ethics code. But if not, I think Congress should require that the Supreme Court adopt an ethics code or even promulgate one for the court. You might have read that about a month ago, the Senate Judiciary Committee, by a 12-11 vote, passed a bill that had been introduced by Senator Sheldon Whitehouse that required the Supreme Court to devise an ethics code. I was tremendously discouraged to see that the vote on the Senate Judiciary Committee was exactly along partisan lines. All 12 Democratic senators voted in favor. All 11 Republican senators voted against. Ethics should not be a partisan issue. The ethics code applies just as much to liberals as to conservative justices. I think it's been perceived as a partisan issue because of the allegations against some of the Republican-appointed justices, especially Clarence Thomas and Samuel Alito. But this isn't about what Thomas and Alito have done in the past. This is about what should be the standard for all of the justices going forward. Given the partisan divide in the Senate, there's no way the Senate would pass this bill because of a Republican filibuster. Given Republican control of the House of Representatives, there's no way that it would pass there. But I think that it's so essential that we do have an ethics code for Supreme Court justices and that apply the same rules as applied to all other judges in the United States. You might have seen the day the Senate Judiciary Committee voted in favor of the White House bill, Justice Samuel Alito gave an interview with the Wall Street Journal where he said it would be unconstitutional for Congress to impose an ethics code on the Supreme Court. Well, first, I think it's inappropriate for Supreme Court justice to address a bill pending in Congress, let alone a bill that would regulate Supreme Court justices. But second, I think here Justice Alito is clearly wrong. There's already federal laws that impose disclosure on the court. Congress regulates the Supreme Court in many ways. Congress sets the number of Supreme Court justices. Congress sets the budget for the Supreme Court. Congress sets the salary for Supreme Court justices. So I think in this way, it would not at all be a violation of separation of powers for Congress to create an ethics code, or at least require the court adopt an ethics code for itself. So what about the coming term of the Supreme Court? It will start the first Monday of October, and that's the third part of my remarks. I want to talk about the next term of the Supreme Court. I expect, again, we'll have many blockbuster opinions. Let me talk about some of what's before the court. There's a case called United States versus Rahimi. It involves a federal law that makes it a crime for a person who's under a restraining order in a domestic violence case from possessing a firearm. Many lives, especially women's lives, have been saved by this. A federal court of appeals, the United States Court of Appeals for the Fifth Circuit, headquartered in New Orleans, declared this law unconstitutional. Why? Well, on June 23rd, 2022, the Supreme Court decided a case, New York State Rifle and Pistol Association versus Bruin. There, the court declared unconstitutional a New York law that said to have a gun in public, you need a permit. To have a permit, you need to show a safety need. You might have seen that just yesterday, the legislature in California passed a bill that would limit the ability of concealed weapons. And the question is, would that be allowed under the Bruin decision? Justice Thomas wrote the opinion in Bruin, and he said, the only regulation of firearms that should be allowed, those that were historically permitted, historically meaning 1791 when the Second Amendment was adopted, or maybe 1868. Well, the United States Court of Appeals for the Fifth Circuit, Rahimi said, there weren't laws in 1791 that kept people restraining orders in domestic violence cases from having guns. That makes the regulation today unconstitutional. But of course, there weren't laws against domestic violence in 1791. There weren't restraining orders at the time. Married women were considered to be the chattels, the property of their husband, and had no legal rights. So why should the regulations of 2023 be limited to what was permissible in 1791? I think the Rahimi case is going to be very important in terms of what kinds of gun regulations are allowed. I think this term of the court, it begins the first Monday in October, is likely to be most known as the term where the court really began to take up issues of the internet and social media. There are a couple of cases that have already been scheduled for argument, Linkey versus Reed, and O'Connor Ratcliffe versus Garrison, and they involve whether a public office holder can cut off someone's Twitter feed or other social media. You might remember that President Trump did this. He cut off the Twitter feed to some people who were reporters who had criticized him. Well, both of these cases involve officials at lower levels of government who use their social media to make announcements about what they were doing in government, but then cut off their critics. Does that violate the First Amendment? I think the answer surely has to be yes. There have been earlier cases that involve whether a city council or state legislature can take away reporting credentials from reporters who criticize the city council or the state legislature. Well, that's unconstitutional. So would this seem to be unconstitutional. It's just more modern technological application. There's a case that we might hear from in the Supreme Court in the next week. It's a case called Missouri versus Biden, and it involves a decision of the United States Court of Appeals for the Fifth Circuit last Friday afternoon, September 9th. I should say I have an op-ed in today's Los Angeles Times on this case. What's involved here is the state of Missouri and some other conservative states and some conservative activists and some anti-vaxxers brought a suit against the Biden administration saying that the Biden administration was coercing social media platforms to take down false speech and encouraging social media platforms to take down false speech. A district court issued a broad injunction against the Biden administration to keep them from coercing or encouraging social media platforms to take down false expression. The United States Court of Appeals for the Fifth Circuit continued the injunction, though narrowed it a bit. Now the injunction applies to the White House, the Center for Disease Control, the FBI. And it says that they can't coerce or encourage the media with regard to false speech. Well, it's certainly the case that the government can't coerce the media in terms of what it publishes or doesn't publish. The problem I have with the Fifth Circuit decision is I don't see any evidence of coercion. No one was threatened with prosecution. The leading Supreme Court case, which the Fifth Circuit relies on, was from 1963, a case called Bantam Books versus Sullivan. A commission sent letters to bookstores saying that it thought that they were selling obscene books and they would be referred to prosecutors for prosecution unless they stopped doing so. And the Supreme Court said that that's coercion. But other cases said, unless there's a threat of prosecution, there's not coercion. There was a lower court case that involved 7-Elevens. It was against its parent company, the Southland Corporation. And it was sent during the Reagan administration by the Meese Commission on Pornography. And they sent letters to 7-Eleven saying, you're selling the magazines Playboy and Penthouse. We believe that's obscene and you shouldn't be selling these magazines. And there was a suit and the Reagan administration won. The 7-Elevens lost. The court said that's not enough for coercion. In terms of encouragement, I don't see any problem with the government encouraging social media platforms to take down false speech. False speech is a serious problem in the context of the internet. False speech is so easily spread and transmitted. And there's a permanence once it's on the internet. And the government can't prohibit false speech. The Supreme Court has said false speech is generally protected by the First Amendment. But the government at least can encourage the social media platforms to take it down. And that's all they did here. The Fifth Circuit, as I said, ruled last Friday, September 9th. It gave 10 days for the Supreme Court to get involved in the matter. So sometime between now and September 19th, we'll hear from the Supreme Court, and that's next Monday. There are two important cases involving the internet where the Supreme Court hasn't granted review, but I'm virtually certain it will at the end of September and hear them then early in 2024. It's Net Choice versus Paxton and Net Choice versus Florida Attorney General. Texas adopted a law that said that social media platforms cannot engage in content moderation. Florida's legislature adopted a law saying social media platforms can't engage in content moderation. Both of these laws are based on the perception that social media companies disproportionately censor conservative speakers. Studies call in doubt whether that's so. The social media platforms constantly engage in content moderation. They take down millions of things a day billions are posted, but they take down so much that might be regarded as hateful or inappropriate. It would be stunning to say that they don't get to make those choices. Well, the United States Court of Appeals for the 11th Circuit struck down the Florida law. It said social media companies decide what to include or not include, that to tell them that they can't engage in content moderation violates the First Amendment, just as it would violate the First Amendment to tell the New York Times or a television station what it can and can't include. But the United States Court of Appeals for the Fifth Circuit upheld the Texas law. So there's a direct conflict between the circuits on this. About a week ago, the Solicitor General of the United States urged the Supreme Court to take these two cases. What's interesting is that the red states, like Texas and Florida, are trying to prevent social media companies from engaging in content moderation, whereas the blue states are trying to encourage more content moderation. California has a law, they've introduced by Assemblyman Jesse Gabriel, that requires that social media companies disclose their policies with regard to content moderation and how they handle things like hate speech. You might have seen that last Friday, Elon Musk brought a lawsuit against this, and now the company's called X rather than Twitter. My sense is that this is different than a state requiring content moderation. This just requires disclosure of policy. There's all sorts of laws that require disclosures. There's laws that require disclosures about the harms of exposure to alcohol, or exposure to toxic chemicals. There's laws that require that workplaces make disclosures. All this is that companies have to disclose their policies. And I think the court's therefore likely to uphold it. But this is just starting out in the federal trial court. As of this point, the Supreme Court has set less than half of its docket for the coming year. The end of September, the court will grant more cases and continue to grant cases through early January to be heard this term. But I think what we're going to see is another momentous term in the United States Supreme Court. So with that, I said I'd say 15 minutes for questions, and we're just about there. Glad to take questions through whatever form you want me to take them.
Okay, I will try and read things as they're put into the, I see them in the chat. There's one here, it says, the Supreme Court has inflicted many inequities on its citizens, and how can we put this right?
The most important thing is presidential elections matter. And of course, I'm speaking to the League of Women Voters, and there's no organization that's done more to advance the importance of elections and free and fair elections. But imagine that Hillary Clinton had won in 2016 rather than Donald Trump. And imagine that Hillary Clinton had replaced Justices Scalia, Kennedy, and Ginsburg. None of the cases that I discussed today would have come out the same way. The dramatic changes in the law in the conservative direction we wouldn't have seen. So I think it's very important that we all get out the vote and the voice the idea that who wins the presidency, the most long-lasting effect is going to who that person puts on the Supreme Court and the lower federal courts. Second, I think it's important that we consider reforms of the Supreme Court and advocating them. I personally favor term limits for Supreme Court justices. I would favor 18-year non-renewable term limits. Well, probably going to take a constitutional amendment, and that's going to require a great deal of organization and a great deal of effort, but I think it would be that. Third, we have to look for ways of advancing rights without the Supreme Court. Sometimes it's going to be through state courts under state constitutions. Sometimes it's going through the legislative process, state or federal. But we have to look at other ways of advancing rights because this is going to be a very conservative court for a long time to come. Clarence Thomas is 75, Samuel Alito is 73, John Roberts is 67, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett are just in their 50s.
Okay, let's see, we have another one. Can you address the court's possible opinion regarding qualified immunity?
Sure. Let me explain what qualified immunity is about. Whenever a government official, federal, state, or local, is sued for money damages for violating the Constitution, there is always an immunity defense. Some government officials have absolute immunity, which means they can't be sued at all for what they do. Prosecutors, what they do as prosecutors. Judges, what they do as judges. Legislators, what they do as legislators, have absolute immunity. All government officials who don't have absolute immunity have qualified immunity. Qualified immunity means that the officer can be held liable only if the officer violates clearly established law that every reasonable officer knows. It has to be right established beyond debate. Increasingly, qualified immunity has become absolute immunity. Both conservatives and liberals have criticized this. And yet so far, the Supreme Court shows no indication that it's going to change the law of qualified immunity. 2 years ago, the most recent case about it was a case called City of Tahlequah, Oklahoma versus Bond. What was involved here was a woman called the police saying she felt threatened by her ex-husband. The police came and found the ex-husband in a garage area, a tool shed area. They were talking to the ex-husband, and he picked up a hammer, and he was twirling the hammer. And the officer said, "Put down the hammer." The man didn't, and the Supreme Court officer shot and killed him. You can watch the video of this particular incident online. And it's clear from watching the video that the man was far enough away from the officers that there's no danger from the hammer to the officers. The Federal Court of Appeals found that the officers used excessive force and there was no qualified immunity. The Supreme Court unanimously reversed and found that the police officer was protected by qualified immunity and couldn't be held liable for the shooting. But as I say, to this point, there's no indication of a Supreme Court that's about to change the law of qualified immunity.
Okay, we have a couple of questions about increasing the number of justices. And one of them says, what are the chances that we might increase the number of justices? And then also, since both extremes can win future elections, what do you think about would be the advantages or dangers of expanding the court?
The number of Supreme Court justices is not set by the Constitution. It's set by federal statute. It's varied over the course of American history from 5 to 10. 9 is a historic accident. There were 10 justices in the late 1860s, and Andrew Johnson was a tremendously unpopular president. He was a Southerner who found himself presiding over Reconstruction because of the death of Abraham Lincoln. And he'd been impeached by the House of Representatives. So Congress wanted to keep Andrew Johnson from filling a vacancy on the Supreme Court. So Congress passed a law saying the next time there's an opening on the Supreme Court, we'll eliminate that seat. And there was an opening, and in 1869, it became 9 justices. It's been ever since. I think there's strong arguments for expanding the size of the Supreme Court. There's nothing magical about 9. I also think that unless something like that happens, we're going to have a very conservative court for many decades to come. On the other hand, I think there's no chance it's going to happen, at least in the foreseeable future. Senate Republicans would filibuster a bill to expand the size of the Supreme Court. Republicans control the House. They're not going to expand the size of the Supreme Court, at least when there's a Democratic president who would make the appointments. So I think there's an argument for expanding the size of the court, but I don't think it's realistic. In terms of the latter question, a danger of expanding the size of the Supreme Court is it would be endless that if the Democrats expand the size of the Supreme Court now, then Republicans will expand the size of the Supreme Court when they have control. And then when the Democrats get back control, they will do that. And if there's any doubt about that kind of response, think about the headlines of today, that the Speaker McCarthy is saying they're going to pursue an impeachment inquiry against Joe Biden, which seems nothing but a response to the fact that there were 2 impeachments of Donald Trump.
Okay, and another question, could you address the court's decisions that are affecting separation of church and state?
Yes, there's been dramatic change in the law here, going with the theme that I started with. Let me talk about 2 aspects of it. One concerns aid to religious schools. For decades, the Supreme Court said that aid from the government to religious schools was limited by the Establishment Clause, the wall that separates church and state. And there were dozens of cases on when may the government give aid to religious schools without that being an impermissible establishment religion. But now the Supreme Court, in 3 cases over the last 6 years, has said that denying aid to religious schools when it's given to secular schools is unconstitutional. It violates free exercise of religion. We've gone from the question of when may the government give aid to religious schools to now when must the government give aid to religious schools. And here I'll pick as my example a case called Carson versus Macon. It came down on Tuesday last year in June. It was June 21st of last year. What happened in Carson versus Macon is the state of Maine has a program. There are parts of Maine that are too rural to support local public school systems. So in these areas, school administrative units give money to parents to send their children to private school. About 5,000 children a year in Maine benefit from this. And the money could be used for any private school, so long as it was secular. It couldn't be used for religious schools. 2 families that wanted to use the money to go to religious school brought a challenge saying, to allow the money to be used for secular education, but not religious education, violated their free exercise of religion. And the Supreme Court, in a 6-3 decision, same 6 conservatives, the majority said, to deny the use of the money in religious schools violates free exercise. These cases are the first time in history that the Supreme Court has ever said that the government is constitutionally required to give aid to religious schools. And as I said, we've gone from viewing aid to religious schools as often being impermissible under the Establishment Clause to now saying aid to religious schools is required when it's given to secular schools. My other example here would be a case from June 27th, 2022, Kennedy versus Bremerton School District. Joseph Kennedy was the high school football coach at a public school in Bremerton, Washington. He described himself as an evangelical Christian and made it a practice of going onto the field after football games, going to midfield, the 50-yard line, and kneeling and praying. Sometimes he'd be joined by players of his team, sometimes players of both teams. A parent complained. The parent said, "My son and our family are atheists. My son feels he won't get as much playing time if he doesn't join in the prayer." The school told Coach Kennedy, "Stop going on the field and praying after games. We'll give you a private place if you want to go pray, but you shouldn't be doing it at the 50-yard line when everyone is still in the stands." Coach Kennedy briefly complied. Then he began the practice of going on the field after games and delivering a Christian inspirational message that he called a prayer. The school placed him on leave and gave him a poor performance evaluation. He sued and said that this violated his free speech and free exercise of religion. The lower courts ruled against Coach Kennedy based on the Establishment Clause. But the Supreme Court, in a 6-3 decision, ruled in favor of Coach Kennedy. Same 6 justices in the majority, Justice Gorsuch writing for them, and Justice Sotomayor writing the dissent. Justice Gorsuch writing for the court said, it violated Coach Kennedy's free exercise of religion and freedom of speech to dissent him for the prayer. For decades, the law was that prayer in schools, in all of its form, violates the Establishment Clause. Now the Supreme Court has said, keeping the teacher from being able to pray, at least in these circumstances, violates free exercise of religion. The Supreme Court's majority rejects the idea of a wall separating church and state. It was Thomas Jefferson who coined the metaphor, there's a wall that separates church and state. This is a court that's very aggressively protecting free exercise of religion.
This is a question that I have, and I don't remember the source or how long ago I read this, but with all the ethics issues coming before the Supreme Court, I had seen something, and I wanted to know if it's true, that Roberts's wife was making a great deal of money by referring essentially recommending interns to many major firms that argue before the Supreme Court, and apparently was well paid for that. I don't know if that's an issue or if it was true or what, but I'd be curious.
You're right in terms of the media. John Roberts' wife's business, what we'd call a headhunter placement, and she gets a fee for those who she places. And she was involved in placing lawyers in the firms that practice before the Supreme Court. It was one of the ethical issues. It didn't get as much attention as some of the Thomas and Alito ethical issues, but it's there as well.
Has he ever commented on that?
No.
Just curious. The other thing I would ask is that, when they were talking about the wedding, the company that said they didn't want to make a wedding website for a gay couple, how is that not how is that a case in controversy if they've never even been asked to make that kind of a, nobody was saying please make it, and they turned them down?
In order to bring a lawsuit in federal court, you have to what's called standing, and that requires that you be injured. And Lori Smith had never done websites for weddings. She'd never turned down a same-sex couple. So how was she injured? What the Supreme Court said is she wants to set up a business to do this, and she wants to know in advance of doing so if she'd violate the law. The notion is somebody shouldn't have to violate the law in order to challenge the law. So if the California legislature passed a law saying no classes can be taught at 8:30 in the morning, and I teach at 8:30 Monday, Tuesday, and Wednesday, I shouldn't have to violate the law, get arrested, and then argue as a defense it's unconstitutional. I should be able to go to court and get what's called a declaratory judgment. When a long time ago in the 1930s, when this came into law that you could do this, somebody said you shouldn't have to eat a mushroom in order to know whether it's poisonous or not. Lori Smith shouldn't have to violate the law to know whether or not she has a constitutional right. But she has to show a likelihood that she would be injured, that a likelihood that she would be asked to do websites for same-sex couples. To show that likelihood, she submitted an affidavit. And she said, here's somebody who's come to me to design a website for a same-sex wedding. That shows there's a real, to use your phrase from the Constitution, case in controversy. Well, after the decision came down, it turned out that it was a fictitious affidavit. It was allegedly from somebody, but the man who it was from was married to a woman, not gay, and had never been in touch with Lori Smith. So it was a fictitious affidavit that was her basis for showing that this was likely. Unfortunately, there's a rule in the law that once a case is decided, you can't go back and attack what was decided on the basis of lack of jurisdiction. So it's worth noting that this case was based on a fictitious affidavit, but it doesn't change anything with it being a binding precedent.
And then there's another question about where, in view of the, I guess, the football coach on the field, where does prayer in classrooms fit in with this following that case?
I'm teaching First Amendment law this semester, and we've just covered that What I said to the students is, I think for right now, there's a distinction between a teacher praying on his or her own, even when students are present, and school-sponsored prayer. So I think based on the Kennedy decision, if a teacher before classes begin, even with students in the room, wants to pray, or a teacher at recess or lunch with students in the room want to pray, even if the students join in, the teacher has the right to do that. But I think that's different than the school requiring prayer as used to exist in the earlier Supreme Court cases where, like, the New York Board of Regents promulgated a prayer that it recited, or Pennsylvania legislature required that verse of the Bible, the Lord's Prayer be said. So I think the distinction is going to be between the individual teacher, where we perceive it's on his or her own, even in the classroom with students there, versus something school-sponsored. I also think it will really matter if there's any evidence of coercion.
And then we have a question that hopefully will lead to a ending on a high note. But it's, I'm feeling scared for my country. What can we hope? What hope can you give to us on the basis of what's coming from the Supreme Court?
I'm scared for the country too, not just for the Supreme Court. Our society is more deeply polarized than it's been at any time since Reconstruction. I worry about the future of democracy. And yet, to answer the question, what I take hope from is the sweep of history. Think about it with regard to equality and freedom. Consider it with regard to race. If you think about what race was, it's the practice of slavery for the first 78 years of American history, or think of the laws, the Jim Crow laws that imposed apartheid on most of the country. I was born in 1953, and separate but equal was still the law. Our country has so much more to do with regard to racial justice and equality, but everyone in this call knows the progress is made. There's an enormous way to go with regard to progress in terms of sex and gender equality, but there's certainly been great advances with regard to sexual orientation. It's only 8 years ago, in 2015, that there was first found a right of gays and lesbians to marry. So I think the late Dr. Martin Luther King Jr. got it exactly right when he said, the arc of the moral universe is long and it bends towards justice. That's what gives me hope.
I think that's probably about it in the questions, unless I've missed one here.
Thank you for having me. Delighted to do it.